All right, welcome everyone. Today we'll be sharing important information for employees regarding New York State's paid family leave. Since its implementation in 2018, paid family leave benefits have been significantly enhanced to further improve the lives of working New Yorkers and their families, including providing more paid time off, more uses for paid family leave, and more financial security. In today's session, we'll provide an overview of New York paid family leave and how it works, including the uses, wage and time off benefits, employee contributions, eligibility, and how you request paid family leave. We'll also cover updates for 2023, information related to FMLA and COVID-19 quarantine leave, and highlight the many resources available to you. So let's get started with a little background. Why do we need paid family leave? For too long, employees have struggled to maintain their jobs when they need to care for a loved one during a specific time of need, whether that's welcoming a new baby, caring for a family member with a serious health condition, or dealing with family pressures when a loved one is deployed abroad on active military service. And more recently, many employees have been challenged by having to quarantine due to COVID-19 or to care for a minor dependent child who is subject to a mandatory quarantine or order of isolation. Employees in these situations face the stress of losing income when they need to take time off to help their family, and they fear their job may be gone when the family situation is over. In response to these needs, New York took action. In April 2016, New York paid family leave, the nation's strongest and most comprehensive paid family leave policy, was signed into law. Paid family leave is employee-funded insurance that helps employees be there for their family when they're most needed. Because of paid family leave, workers across New York no longer have to choose between caring for their loved ones and their jobs, as we now have employee-paid insurance to help in these critical times. Paid family leave provides job-protected, paid time off so you can bond with a newly born, adopted, or foster child, care for a family member with a serious health condition, or assist loved ones when a family member is deployed abroad on active military service. Under legislation signed into law in March 2020, paid family leave also provides paid time off and job protection so employees can care for themselves or their minor dependent child when under a mandatory order of quarantine or isolation due to COVID-19. We'll go into more detail on these uses later in the presentation as they're a bit different from the others. In addition to paid time off, New York's paid family leave also has strong employee protections. You are guaranteed to return to the same or comparable job after taking paid family leave. A comparable job is defined as a position with comparable employment benefits, pay, and other terms and conditions of employment. You are guaranteed continuation of health insurance while you're out on paid family leave, on the same terms as if you had continued to work. If you contribute to the cost of your health insurance, you must continue paying your portion of the premium while on leave. You are also guaranteed protection from discrimination and retaliation. Requesting or taking paid family leave cannot be held against you. Let's take a closer look at the three basic uses of paid family leave. We'll start with bonding with a child. Paid family leave provides both parents time to bond with a new child within the first 12 months of the birth, adoption, or foster placement of the child. Parents who work for different employers can take paid family leave at the same time to bond with the same child. Parents who work for the same employer can take it at the same time unless their employer prohibits it. And in that case, they can take leave separately over the first 12 months following the child's birth, adoption, or foster placement. It's important to note that expectant parents cannot take paid family leave for their own pregnancy. They can take it after the baby is born because paid family leave is used to care for someone else. A parent may be able to take paid family leave before the actual adoption or placement of a child if an absence from work is required for the adoption or placement to be finalized. Paid family leave is also available for employees to care for a spouse, domestic partner, child or stepchild, sibling, parent or step-parent, parent-in-law, grandparent, or grandchild who has a serious health condition. So new in 2023, siblings are also included in family members who are covered by paid family leave. You should check with your employer for details on when this goes into effect for your policy. A few other important notes for family care. Domestic partner is defined broadly under the paid family leave law. It includes people who are not related by blood in a manner that would bar marriage in New York State and who are dependent on one another for support. For example, an employee may be able to prove that they are in a domestic partnership by showing that they own property together or have children in common. A legal relationship is not necessary. It doesn't matter if these family members live outside of New York State or even outside of the country. Employees can take paid family leave to care for their family members as long as they are within close and continuing proximity. In other words, present at the same location as the family member they're caring for during most of the paid family leave period. This may include necessary physical care, emotional support, visitation, assistance in treatment, transportation, arranging for a change in care, assistance with essential daily living matters, and personal attendant services. In order to take this type of leave, your family member must have a serious health condition. A serious health condition is defined as an illness, injury, or condition that requires either inpatient care in a hospital, hospice, or residential health facility, or continuing treatment or supervision by a healthcare provider. A COVID-19 diagnosis may qualify as a serious health condition. Here are some examples of other conditions that may qualify as a serious health condition. Maybe you need one or more full days to care for your mom when she undergoes chemotherapy, or your spouse or domestic partner had surgery and needs help recuperating at home, or your child is undergoing treatment for addiction and cannot attend school for a period of time. These are situations that may qualify for paid family leave and may be certified by the healthcare provider if they believe that the condition constitutes a serious health condition. The insurance carrier will make the final determination as to whether such conditions qualify for paid family leave. Since February 2019, paid family leave also explicitly includes support for organ donors. Former Governor Cuomo signed legislation to expand the paid family leave law's definition of serious health condition to explicitly include preparation for and recovery from surgery related to organ or tissue donation, ensuring those who donate can be cared for by their eligible family members under New York paid family leave. Non-serious medical conditions such as the common cold or flu, routine dental work, or cosmetic treatments are generally not included. However, if medical complications arise and your family member then meets the guidelines for a serious health condition, it may be eligible. The third type of leave is for assisting during a military deployment. Paid family leave benefits are available when a family member is deployed abroad on active military service or who has been notified of an impending call or order of active service abroad and assistance is needed. Reasons for paid family leave for an active service deployment are the same as the military provisions of the Federal Family Medical Leave Act, or FMLA. They cover the employee's spouse, domestic partner, child, or parent. There are several instances where paid family leave will help, which are shown here on the screen. As we mentioned, there are also 2 uses of paid family leave related to COVID-19, which we'll cover in a few minutes. Now let's look at the program updates for 2023. Eligible employees are able to take up to 12 weeks of paid family leave at 67% of their average weekly wage, capped at 67% of the New York State average weekly wage. An employee's average weekly wage is based on their last 8 weeks of pay prior to taking paid family leave. For 2023, the New York State average weekly wage is $1,688.19. This means the maximum weekly benefit for 2023 is $1,131.08. And this is $62.72 more than the maximum weekly benefit for 2022. It is important to note that employees can take this paid time off all at once or intermittently, but it must always be in full day increments. To estimate your wage benefit, you can use the 2023 calculator on the Paid Family Leave website at paidfamilyleave.ny.gov/PFL Benefits Calculator 2023. Paid family leave is fully funded through employee contributions. The contribution rate is reviewed annually and is subject to change by the New York State Department of Financial Services. In 2023, the payroll contribution is 0.455% of an employee's gross wages each pay period. The maximum annual contribution is $399.43. This is $24.28 less than in 2022. Employees earning less than the current New York statewide average weekly wage of $1,688.19 will contribute less than the annual cap of $399.43, consistent with their actual wages. To estimate deductions, you can use the 2023 payroll deduction calculator on the Paid Family Leave website at paidfamilyleave.ny.gov/paid-family-leave-calculator 2023. So, to summarize the updates for 2023, The maximum weekly benefit is increasing from $1,068.36 to $1,131.08. Also, as of January 1st, 2023, employers may deduct at the rate of 0.455% of an employee's gross wages each pay period, and that is capped at an annual maximum of $399.43. Now that we've covered the types of leave, the benefits, and the costs, let's discuss who's covered and eligible for paid family leave. Most employees who work for private employers in New York State are covered under paid family leave. If you work for a public employer, your employer may opt into the program. If you're a public employee represented by a union, you may be covered if paid family leave is collectively bargained. For covered employees, eligibility for taking paid family leave depends on meeting specific requirements for the amount of time that employees have worked for their employer. Full-time employees, those who regularly work 20 or more hours per week, are eligible for paid family leave after 26 consecutive weeks of employment with the same employer. Part-time employees, who work a regular schedule of less than 20 hours per week, are eligible after working 175 days, which do not need to be consecutive. Citizenship or immigration status is not a factor in employee eligibility. In 2021, Governor Hochul signed an amendment to the workers' compensation law, which expanded coverage for domestic workers. Previously, domestic workers were only required to be covered if they worked at least 40 hours per week for their employer. Domestic workers who are hired directly by a private homeowner and who work 20 or more hours per week for the private homeowner are now required to be covered for paid family leave. These workers are eligible once they've been in employment with that employer for 26 consecutive weeks. Paid family leave coverage is not optional for eligible employees. You can waive coverage if you regularly work 20 or more hours per week, but won't be in employment 26 consecutive weeks, or if you regularly work less than 20 hours per week and you won't work 175 days in a 52-week period. Seasonal workers are a good example of this, as they may work full-time, but only for 3 months out of the year. If you meet the criteria for waiving coverage, your employer must provide you with a waiver form, which is also available on the Paid Family Leave website. If you waive coverage, you will not make contributions and you will not be eligible for paid family leave benefits. Employers should keep a copy of your waiver on file. If your schedule changes so that you no longer qualify for a waiver, your waiver will be automatically revoked within 8 weeks of the schedule change. You can also voluntarily revoke a waiver at any time. If your waiver is revoked, your employer will begin taking paid family leave contributions and collect any retroactive amounts due. Now we'll cover how to request paid family leave when you need it, as well as how disputes and discrimination issues will be handled. If you're an eligible employee, the maximum benefit is available to you once every 52 weeks. When you're ready to request leave, there are 3 basic steps. Step 1 is to notify your employer at least 30 days before the start of your leave if it's foreseeable. If not, as soon as possible. Step 2 is to complete the request forms. And step 3 is to send all the required forms to the insurance carrier. The insurance carrier must pay or deny your request within 18 calendar days of receiving the completed request or your first day of leave, whichever is later. You must submit your completed request package to your employer's insurance carrier within 30 days after the start of your leave to avoid losing benefits. You can get paid family leave request forms from your employer's insurance carrier, or directly from paidfamilyleave.ny.gov/forms. If for some reason your paid family leave request is denied, or you have another claim-related dispute, such as the amount of benefits or timeliness of a carrier's decision, you may request to have the denial reviewed by a neutral arbitrator. Your insurance carrier, or employer if they're self-insured, will notify you of the reason for denial and provide you with information about requesting arbitration. Arbitration for paid family leave is handled by NAM, National Arbitration and Mediation. For more information on arbitration is available at nystfla.namadr.com. As mentioned earlier, your employer may not discriminate against you for requesting or taking paid family leave, and you are guaranteed job protection with the same or comparable job upon return from paid family leave. If your employer does not return you to the same or comparable job, terminates you, reduces your pay and/or benefits, or disciplines you in any way as a result of you requesting or taking paid family leave, you can file a discrimination claim with the Workers' Compensation Board. An administrative law judge may order an employer to reinstate an employee, pay any lost wages, pay attorney's fees, and pay up to $500 in penalties. The process and forms are available at paidfamilyleave.ny.gov, or you can call the Paid Family Leave Helpline for assistance at 844-337-6303. We are frequently asked about the similarities and differences between paid family leave and FMLA. There are several similarities between New York's paid family leave and the Federal Family and Medical Leave Act. Both provide leave for bonding with a child, caring for a family member with a serious health condition, and assisting when a family member is deployed abroad on active military service. You are also guaranteed that you will return to the same or comparable position, and your health insurance will continue on the same terms as if you had continued to work. If you contribute to the cost of your health insurance, you must continue to pay your portion of the premium cost while on leave. There are several key differences. PFL is paid, while FMLA is not paid. Almost all private employers will carry PFL insurance. FMLA does not include insurance, and it has a 50-employee threshold for eligibility. The length of time you must work is different. For PFL, if you regularly work 20 or more hours per week, you must be in employment for 26 consecutive weeks for that employer. And if you regularly work less than 20 hours per week, you must work 175 days for the same employer, which do not need to be consecutive. For FMLA, you must have worked for a full year and 1,250 hours in the last 52 weeks to qualify. The biggest distinction may be that under New York's paid family leave, you are taking leave to care for someone else, not for your own health condition. FMLA allows you to take leave for your own health condition. PFL is only taken in full-day increments, while FMLA may be taken hourly. And also under PFL, you do not need to use other paid time off first. As we mentioned earlier, there are 2 additional uses of paid family leave that took effect under emergency legislation enacted in response to the COVID-19 pandemic. The legislation allows for a combination of New York paid family leave and disability benefits if you are under an order of mandatory or precautionary quarantine or isolation due to COVID-19. This is the only time that you can receive paid family leave and disability benefits at the same time. It also gives you access to paid family leave if your minor dependent child is under an order of mandatory or precautionary quarantine or isolation due to COVID-19. You may apply for a combination of New York State paid family leave and disability benefits to receive your full pay up to a cap for some or all of the quarantine period. You may be eligible to receive 67% of your pay, up to a maximum weekly benefit of $840.70. Disability benefits will make up the difference in your salary up to a maximum weekly benefit of $2,043.92 for a combined total of $2,884.62 per week. There's no waiting period, and you will have job protection throughout the quarantine. Depending on the size of your employer, paid sick leave benefits may also be available, and those must be used prior to any PFL and disability benefits. Note, this does not apply if you work for public employers or an employer with 100 or more employees, because those employers are required to provide 14 days of paid sick leave. If you request leave for your minor dependent child's quarantine or isolation, you may be eligible to receive 67% of your pay up to a maximum weekly benefit of $840.70. More detailed information about taking paid family leave for your quarantine or your child can be found at paidfamilyleave.ny.gov/COVID-19. There you'll also find information about the New York State COVID-19 paid sick leave requirements, FAQs, application forms, and more. As you think about how paid family leave may be able to help you and your family, there are resources to assist you. Complete details on paid family leave are available at paidfamilyleave.ny.gov, along with other resources including paid family leave request forms and fact sheets, weekly deduction and benefit calculators, updates for 2023, and information about paid family leave quarantine leave benefits. If you are thinking about taking paid family leave soon, you can download the forms now and get started filling them out. You can also contact the Paid Family Leave Helpline at 844-337-6303 for assistance. If you are not already subscribed for email updates on paid family leave, you can subscribe by clicking Get Updates on the bottom of the paidfamilyleave.ny.gov homepage. We hope you have found this presentation helpful. Thank you for the opportunity to discuss New York's landmark paid family leave with you. please keep in mind that the board is unable to provide legal advice, which includes guidance about what you should do in specific situations. If you have specific questions or concerns about a request for paid family leave, you should contact your employer's disability and paid family leave insurance carrier, as they are the entity that makes the decision to pay or deny benefits.
Thank you, Courtney. And that does it for our presentation. So at this time, we will start answering your questions. We do have some questions that have already come in. So Courtney and I are going to take a couple minutes to review those before we get back to you. Real quick, we do have a couple questions asking for a copy of this presentation. If you go to the Paid Family Leave website, which is up on your screen, paidfamilyleave.ny.gov, and you go to the webinar section, we do have a copy of this slide deck as well as some other paid family leave slide decks available. We also have recorded versions of this presentation on our paid family leave website, and those are also available on our YouTube channel. So if you go to YouTube and you search for the New York State Workers' Compensation Board, you can find some paid family leave webinars on there as well. So again, we have some questions that have come in already and are coming in now. So Courtney and I are going to take a brief period of silence to review those. We will be back with you shortly. Thank you.
Okay, so the first question I see here is, are employees currently suspended or using accruals or on income protection plan eligible for PFL? So I can't give legal advice, so I'm not going to be able to comment on these kind of specific things, but the regulations define a day of paid family leave as a full day that the employee was prevented from performing work for the employer because the employee used paid family leave. So if it's a day they don't normally work, or they're not working for some reason or something like that, and they're not prevented from performing work because of PFL, they're likely not going to be able to take PFL for that day. Okay, the next question I see here is, does my employer still have to pay me COVID paid sick leave based on the employee count outside of PFL? So if you go to the website and go to the COVID-19 section of the PFL website, it breaks down, depending on the size and type of employer, what COVID-19 quarantine leave benefits the employer is required to provide. And so if they are required to provide you COVID paid sick leave, those days have to be used before you're eligible for any PFL, if your employer is even required to provide PFL for COVID-19 quarantine. The next question I see here is, can you take parental leave incrementally? So for example, 2 days a week for X amount of weeks. So there's nothing in the PFL law preventing you from doing that. So intermittent leave is available under paid family leave. You do need to keep in mind that if your employer is also subject to FMLA and PFL, and they're designating a period of time as FMLA, they can require you to take PFL at the same time if it's for the same qualifying event. So it's kind of the only caveat. But generally speaking, you can take paid family leave however you want. It just has to be, for bonding leave, it has to be taken and completed within the first 12 months following the child's birth or placement. And keep in mind that you do also need to give your employer notice of foreseeable leave. The next question I see here is, if my hours continuously fluctuate, am I still eligible to opt out? So the waiver requirements are, if you regularly work 20 or more hours per week and you won't be in employment for 26 consecutive weeks, so it's usually like your seasonal workers, you can execute a waiver. If you regularly work less than 20 hours per week, but you're not expected to work 175 days in a year, you can execute a waiver and your employer should provide you one. If your schedule ends up being such that you don't qualify for a waiver anymore, keep in mind that the waiver is going to be revoked, and then your employer can take any retroactive contributions that you should have been paying because it ended up that your schedule didn't actually qualify you for a waiver. Okay, the next question I see here is, somebody has an employee who is refusing to fill in some sections of the caregiver application, like they won't provide the parent's social security number and doctor info, and it says we will submit the complete application, so it seems like you may be the employer. So I just want to clarify a couple things. First, it's the employee's responsibility, not the employer's responsibility, to submit the completed request for paid family leave. So the employer is not involved in submitting the form at all. Secondly, the employee is not required to provide the entire form information. It's the insurance carrier that's going to actually make the decision to pay or deny the request for paid family leave. But and then, yes, for clarification, saying, yeah, the employee does have to fill out the sections and provide documentation. The healthcare provider has to fill out their section. There is an employer section. That's what they're required to give you. You have 3 business days to fill it out, return it to the employee, and the employee sends the entire package to the carrier. The employer is not involved. But if the employer, for some reason, refuses to fill out their section within 3 business days, the employee can still send their completed application to the carrier, and the carrier will still process it. The next question here is, for family care, are any documents required to verify proof of relationship as a sibling? So the law does not require it. If an insurance carrier has reason to suspect that this isn't an actual family member, they're free to investigate and ask for additional proof, but the law just, the same with any other family member, bonding leave, you have to provide proof of relationship to the child if you're not the birth parent, but the documentation for any type of leave does not require specific documentation for proof of relationship, and sibling is no different. The law just added sibling as a family member, but if a carrier has reason to suspect that this is not a qualifying family member, they are free to ask for additional clarification. Okay, the next question here is, does the employee have to get the form from the website, complete it, and send it to the employer, or should the employer be sending the PFL form to the employee? So if you have the forms and you know that your employee is looking to take paid family leave, it would be a good thing to send them the form, but the forms are also available on the PFL website. Okay, the next question here is twofold. When does the employer submit the PFL forms, and when will I find out if I'm approved for the full 12 weeks? So your employer does not submit the PFL form. It's you as the employee. It's your responsibility to submit the form. And the insurance carrier has 18 days from receipt of your completed request or your first day of leave, whichever is later, to approve or deny the claim, so to pay or deny the request for paid family leave. So it's within 18 days, either from receipt of the completed request or the first day of leave, whichever is later. So that's the time frame. But if you are approved, you'll be paid back through your first day of leave. It's just that they have that time built in to process and pay or deny your request. Okay, the next question here is, do you have to wait until the family member is ill to apply for PFL? So the answer here is you are not eligible for paid family leave to care for a family member with a serious health condition unless you have a family member with a serious health condition. So if there is a planned surgery or something like that and you're going to need to care for them, you're free to fill out the forms. Carriers, however, are not required to accept pre-filed claims. And again, you're not eligible until there is a serious health condition. But if there's a planned surgery and that this is something that's coming up, you're free to contact your employer's disability and paid family leave insurance carrier. They may accept a pre-filed claim, but they don't have to. Okay, next question here is, I applied online on MetLife's website, but the forms they gave me are incorrect. I want to care for my mother. I called the carrier, but I was told that I have to wait until a caseworker contacts me. So you are free to get the paid family leave forms from our paid family leave website, and a carrier has to accept them. So you don't have to use the MetLife, if MetLife has branded forms. I'm not sure if they do or not. A lot of carriers do. But you're not required to use their version of the form. You can use the paid family leave version that's on our website, and the carrier has to accept them. Okay, next question is, assuming that employee has worked 26 weeks and so they're eligible, is there a maximum amount of claims they can claim for PFL? So employees are limited to 12 weeks of PFL within a 52-week period, and there's also a combined maximum of 26 weeks of statutory disability in PFL in a 52-week period. So that's a rolling 52-week period, not a calendar year, but if the employee has 10 qualifying events, they could take paid family leave for all of them, but they're still going to be limited to a maximum of 12 weeks of PFL regardless of how many qualifying events they have. Okay, I see another question here. How is it verified that someone is truly your sibling? So again, if the carrier has reason to suspect that the family relationship is not what an employee is claiming or that the employee is lying, they're free to investigate. They're the ones who are processing and paying or denying the request for paid family leave. But this is not a new situation for paid family leave. So the new law just added a new family member in siblings. But it's the same as, your mother, father, grandchild, grandparent. These are all family members that have been in PFL since the beginning. The law simply just added a new family member, which is siblings. All right, next question here is, can PFL and FMLA run at the same time? And the answer is yes, if it's for the same qualifying event. So if your employer is subject to FMLA and PFL, and you're taking leave, for example, bonding leave, so it's something that qualifies for both FMLA and PFL, your employer can require you to take any available bonding leave under FMLA at the same time as PFL. The next question here is, I thought that quarantine requirement has been removed, so why is this a benefit? So the COVID-19 quarantine leave legislation does not contain an end date, so it is still the law. So we are just providing you the information about the law that was enacted in March 2020. The next question here is, my employer has not had a request for intermittent leave, so they want to know, are benefit days, so vacation, accrued while out on PFL? So the PFL law says that you can't lose a benefit that you've already accrued while you're out on PFL, but nothing in the law entitles you to accruing benefits that you would have otherwise accrued had you not been on paid family leave. So it's really going to come down to your employer's policy and what the policy says. But generally speaking, like if you're out and you would otherwise have been accruing leave, but because you're out under your employer's policy, you wouldn't, that's not necessarily against the law. This is very, very case specific, and I can't give legal advice, so I'm not going to be able to tell you yes or no to your situation, but that's the general rule. Next question is, if I take PFL, so bonding PFL with a child, and then 6 months later, can I take PFL to care for a sick child? So the answer is, if you have PFL available to you and the sick child has a serious health condition, then yes, but again, there is a maximum of 12 weeks of PFL, regardless of how many qualifying events you experience in a 52-week period. So if you took 12 weeks of bonding leave, and then a few months later, you have another qualifying event, you may not have any PFL available to you. So it's a rolling calendar year. So each day that you're requesting paid family leave, the insurance carrier is going to look back on the previous 52 weeks, and that's how they determine if there's any PFL available to you. Okay, next question here is, can a claim be considered complete prior to the birth of the child, or is the birth certificate required before it can officially be completed or paid? Just wondering about lag time for payment. So there's no requirement that you include a birth certificate. There are other forms of documentation that are that you can use, and those are available in the instructions on the form. But PFL insurance carriers are not required to accept pre-filed claims. So before a child is born, you don't have a qualifying event because it's bonding after the child is born. So until that happens, you're not eligible for paid family leave. Some insurance carriers do accept pre-filed claims. So say, here's the healthcare provider certification saying that, the child is due to be born on X date, and these are the 12 weeks I want to take, or however many weeks, whatever. Some carriers will accept a pre-filed claim, but they don't have to. So this is really a carrier-specific question. Okay, next question here. How do I notify my carrier and employer of the days I'm on intermittent leave? So this isn't specifically addressed in the PFL law and regulations. Like, you have to, in writing, would be good. Like, there's no specific requirement for how you do it. If you have specific questions on how to notify your carrier, like if you just put days are intermittent or estimated on your request for paid family leave, you may want to talk to the insurance carrier and see how and in what manner they want notification, and same with your employer. Question here, an employer can pay for the PFL insurance in its entirety, correct? Employees don't have to make a contribution. So that's correct. If an employer wants to pay the PFL insurance policy premium without taking deductions from their employees, they're welcome to do so. They don't have to. It is designed as an employee-funded benefit, and the law allows employers to take deductions, but they don't have to. If they want to pay for the insurance premium on behalf of the employees, they're free to do that. Next question here is, where do I find, or my employer find, the waiver to provide to myself as the employer? So that's on paidfamilyleave.ny.gov under forms. You can find a template waiver. It is a template. Your employer may have a different version that they use, but the template has all of the relevant information, and you can fill that out and give it to your employer if you qualify. Question here, prior to and return of PFL, if the employee is informed of a decline in work available for the company as a whole, can this be seen as a penalty against the employee who took leave, or is this due cause for a potential layoff? So I cannot provide legal advice, so I'm not going to be able to tell you yes or no, or this is discrimination or it isn't. What I can tell you is that under the law, employees are entitled to return to the same or comparable position upon return from leave. If the employee thinks that they've been discriminated or retaliated against, they are free to file a discrimination claim. The employer would have an opportunity to present their side and show, this was not in response or in any way related to PFL. But if an employee thinks that they've been discriminated against, they can file a discrimination claim, and it will go to a workers' compensation law judge who will make a determination. Okay, next question here is, if the father is not married to his pregnant girlfriend, does he have to prove that he lives with her if he wants to be able to care for her prior to the baby's birth? So there's no requirement to prove that you live with someone. Domestic partnership is defined broadly under the paid family leave law, but it is going to be a very, very fact-specific determination if you're going to take leave to show that they're your family member. If you're asking about bonding leave, there's no requirement that they live together at all to be able to bond with the baby. They would just have to show that they are a parent. Next question here is there a way to get paid out the leave, so get the benefits but not take the actual time? The answer is no. Paid family leave is a time off benefit, and it's a wage replacement benefit. And like I said, earlier in the presentation, a day of paid family leave is defined as a day that you took paid family leave. So you were prevented from performing work for the employer because you took paid family leave. You cannot work and receive PFL benefits at the same time. Okay, next question here is, what is the difference between PFL Part 1 and PFL Part 2? I'm not sure if you mean the PFL 1 and the PFL 2, in which case the PFL 1 is the general form that you fill it out for every leave type, and PFL 2 is the bonding leave specific one. If you're talking about PFL Part 1 and PFL Part 2, I do not have the form memorized, but there are very, very detailed instructions on the PFL forms. So that should kind of give you some information. If PFL is denied and the employee was out already, can the employer proceed with disciplinary action for the time missed? So again, this is asking whether or not an employer's actions constitute discrimination. Can't provide legal advice, so I'm not going to be able to tell you yes or no. But keep in mind that employees cannot be discriminated against because they took or requested paid family leave. So again, if an employee thinks that they've been discriminated or retaliated against because they took or requested paid family leave, they're free to file. The employer would have an opportunity to present their side, and a law judge would make a determination. But this is, a very fact-specific situation again, and I can't give legal advice. All right, next question here. I'm expecting my first child in May 2023. Should I submit my forms 30 or 18 days prior to my leave, and where to? So again, we've talked about this a few times, but insurance carriers are not required to accept pre-filed claims. So you are free to contact your employer's PFL insurance carrier and ask them if they would accept a pre-filed claim, but they do not have to. So you have 30 days from the first day of leave to apply without risking any loss of benefits. If you want to submit your leave ahead of time, your paid family leave request form ahead of time, you can ask the carrier, but they do not have to allow you to do an early pre-filed claim. And your PFL application goes to your employer's disability and PFL insurance carrier. Okay, the next question here is asking for an example of if the employee has multiple qualifying events. So for example, if an employee has a baby and took PFL, can they also take PFL to assist a family member within the same 52 weeks? Okay, so using that as an example, an employee has a baby. Let's say they take 6 weeks of paid family leave to bond with that baby. So that's 6 weeks gone. And then 4 months later, they have another qualifying event, and it's their father needs care because they have a serious health condition. The carrier is going to look back 52 weeks for that second qualifying event, so that to care for the father. They're going to look back 52 weeks because it's a rolling calendar year. They're going to look back 52 weeks and see how much leave is available. A few months ago, this employee took 6 months of leave, so that's within the last 52 weeks, or 6 weeks of leave, I'm sorry. So that's within the last 52 weeks. So the employee only has 6 weeks available to them for this qualifying event. Same thing happens again if two weeks after they come back from leave, there's another serious health condition, they want to take more bonding leave and the kid is not yet 1 year old, whatever, same thing, the carrier is going to look back. But now say they took 6 weeks and then 6 weeks, and then 2 weeks later they want to try to take more leave. The carrier is going to look back 52 weeks and they're going to say, oh, 6 plus 6 is 12, that employee does not have any more time available to them during that 52-week period. It is rolling, so as the year goes on, they may gain days back at a time, but it is a rolling calendar year. Can you confirm that the maximum amount of pay an employee can receive while on leave is 60% per week cap? So the maximum benefit is 67% of the New York statewide average weekly wage. So it's not 67% of the employee's wage. It's 67% of the New York State average weekly wage is the max. So if you make over the New York State average weekly wage, your benefit is going to be capped at 67% of the New York State average weekly wage. If you make less than that amount, your benefit will be 67% of your average weekly wage. Okay, the next question I see here is the New York State website says that employers cannot force employees to use paid time off during PFL. That's true. The next part here says, would a company's 100% paid parental leave policy be considered paid time off? Additionally, if they offer 100% paid parental leave policy for 12 weeks, can the employee then take another 12 weeks, or do they run concurrently? So whether or not an employer's leave policy is concurrent with paid family leave, how they interact is going to depend on the employer's policy. So it's going to depend on the terms of that policy. The employer can't abridge the right of the eligible employee to take PFL. So, but, you know, it is possible that they run concurrently or something like that, but they just can't take away the right of the employee to take paid family leave. But it depends on the terms of the employer's policy for how they interact. For the 100% paid parental leave policy, be considered paid time off. So when we're talking about they can't force employees to use paid time off, we're talking about accruals, right? So I have 4 weeks of paid paid time off that I've accrued over the last. An employer can't say you have to use those 4 weeks of paid time off in order to get paid family leave. It doesn't sound like that's what we're talking about here. This sounds like a paid parental leave policy, meaning maternity, paternity leave policy that isn't related to accrued paid time off. You can't force an employee to use accrued paid time off, meaning you're depleting their vacation time bank. But if this is just a separate policy that any employee who becomes a parent is entitled to, that's not going to be considered accruals because you're not accruing it. It's a benefit for a specific event. Employees can't receive more than 100% of their wages during paid family leave, but if you pay them 100% of their wages, you can request reimbursement from the PFL insurance carrier, assuming that the terms of policy say that it's concurrent. You can also allow them to take it consecutively, so it really does depend on what your policy says.
All right, thank you, Courtney. That is all the questions we have, so we're going to go ahead and wrap up. I want to thank you all for joining us today, asking some very good questions. We always appreciate your participation. Just want to remind you before we sign off that you can sign up to receive paid family leave news, including information on future webinars straight to your inbox. To sign up, please visit the Paid Family Leave website. Scroll down to the bottom of the homepage and select Get Updates. And we do also distribute information via social media. So make sure you follow the Workers' Compensation Board on Facebook, Twitter, Instagram, and YouTube. And one last time, I do want to remind you the YouTube page does have previously recorded webinars on paid family leave. So if you need a refresher at any point, feel free to go to the YouTube page, find the PFL webinar you're looking for, and it should be there, and you can get all the information we gave you today again. All right, so thank you all for joining us. Please continue to stay safe and enjoy the rest of your afternoon.